Just briefly, Your Honor, I'll just reiterate that even Mr. Parkman in his argument agrees that Judge Giles considered all of the circumstances about the violations, all the adverse circumstances in his findings of fact, and that is not an abuse of discretion. So.
Okay. All right. I think I've heard enough here to move on, with this. As I stated earlier, this is a matter before me, this court, and me directly as the acting presiding judge in the absence of the presiding judge at the criminal division, Judge Ewell. And I thought I was having the worst week that I could have yesterday after trying, 2 cases involving criminal sexual conduct involving minors. And just when I thought that my day was ending, I see converging on this courtroom, all these persons and people from the meeting and so forth. And I thought maybe I had some rich uncle or somebody who died and left me $1 billion, and somehow I got word of it before I did. But anyway, my jury has a decision, so we'll get to them in a minute. But anyway, beyond that, let's get to this. Just put the geography aside. The issue before this court, as I said, is whether or not there was an abuse of discretion. I take seriously the nature of the court rule here, as I said earlier, that this is a matter that's prior to the arraignment on the information, in spite of what was said about the procedure that was done yesterday, waiving a preliminary exam, and then having the bond conditions and modified or changed after that and so forth, and the argument about, well, this is formally before this court to make that decision. I ruled, and I maintain the ruling that this is a prior to arraignment on the information circumstance, and that according to the rule, the reviewing court, this court, may not stay, vacate, modify, or reverse the release decision except on finding an abuse of discretion. Then we get to, I think, the general meaning of discretion, and that has been defined in different kinds of ways by certain cases and circumstances. And basically what I have used in some situation in terms of some definition of that is that the standard, of course, in testing for an abuse of discretion is a narrow one. This court, the reviewing court, cannot, of course, substitute his judgment for that of the examining magistrate or the district court judge. And people read Charles D. Williams, 386, Michigan Reports 565, 573, 1972, but it's an off-quoted case regarding the term discretion. It says, the term discretion itself involves the idea of choice, of an exercise of the will, of a determination made between competing considerations. In order to have an abuse in reaching such determination, the result must be so palpably and grossly violative of fact and logic that the evidence is not the exercise of judgment, but defiance thereof, not the exercise of reason, but rather of bias or passion. Another view of judicial discretion was presented in the case of Langnes, Langnes v. Green, 282 U.S. 531. It's a 1931 case, but in a Supreme Court case, People v. Talley, then Justice Leving said this: when invoked as a guide to judicial action, it means a sound discretion, that is to say, a discretion exercised not arbitrarily or willfully, but with regard to what is right and equitable under the circumstances and the law, and directed by the reason and conscience of the judge to a just result. Thus, when the issue of abuse of discretion is raised, this court, the reviewing court, must engage in an analysis of the record by weighing the consideration involved in the district court decision. And as I said, I have reviewed and looked at what was said by Judge Giles yesterday, even before I received the full transcript from the lawyers, this morning. I think it was published in one of the dailies here, and I think it was in an article related to some by Mr. Swickard here from the Free Press. But anyway, the gist of what he said in making his determination and decision was what I was focused on. I wasn't concerned with so much with the remainder of the record, what the lawyer said, what the defendant said, and all those things, but focusing on his statement and whether or not there was an abuse of discretion. I think it's quite obvious, from the record that he made, and as I've already indicated, that Judge Giles was dealing with an aggregate of circumstances, and when a defendant who he perceived to almost defiantly and arrogantly violating, court procedure. And as I indicated in my comments to Mr. Parkman, I don't, you don't blame the defense counsel for something like that when you have allegedly a responsible person who was able to make those kinds of decisions. Not only was Judge Giles concerned with what appeared to be a progression of circumstances, such as he set the bond initially at a $75,000, I think, personal bond. As he said, he had basically no restrictions, on travel and anything like that. Then something else came up. He reviewed it. He put a 10% provision on that to have a $7,500 posted. And somewhere along the way, it was found out that he had a hearing to take testimony from persons who said that the mayor engaged in activity for which some other criminal charges, may be brought. And also some comments that were allegedly made to the officer at the time that this event, occurred. Things that are totally inconsistent with what one would think and expect of not someone in that position, but anyone who is on bond to a court and under court restrictions to follow, certain rules, unless there is a plain lack of basic common sense or just plain old arrogance and defiance. And either one of those trouble me, because if you're not using good sense and arrogance, both of those trouble me for someone in that position. But this all, I think, to assess the general record of what Judge Giles did, he was concerned with these continuing kind of circumstances here that seem, and I can understand from his perspective, of course, and what he said, at least, and discerning from that the utter frustration of someone who seems to just want to completely and arrogantly and defiantly violate, his conditions, of bond. And I think that is the vein in which he acted and which he made the decision, that he made. And based on how I understand discretion, I have no problem with that part of it and why he did, what he did in terms of making the revocation and making, that decision. As I just indicated, my basic concern is with the fact of remand without any kind of bond, with my understanding of what the basic intent of MCR 6.106 entails and involves. Now, as indicated by the prosecution, and I totally agree that the MCR 6.106 certainly says that one has a right to bond and one should not be denied bond unless there are some certain kind of circumstances. But I do think that in the exercise of discretion, a judge who makes some basic rules from the very beginning expects that those rules are going to be followed, and that if he particularly tells the person what those rules are, and that person should understand what those rules are and what are the conditions of that bond, that those should, be followed, and without any kind of reservation or excuses, for that, regardless. I think that Judge Giles asked, first of all, was there any kind of an emergency? And it should be said that he did not totally say that the defendant could not go or do certain things. He just set some conditions, for it. If you got to go somewhere, you got to do something. If you know within 48 hours, let me know, or whatever time else, you need to know, let me know, and those things, can be worked out. And he also, Judge Giles also made note of the fact that certainly if this visit to Canada was set up, I'm sure that it takes phone calls and all kinds of things, to do that. And it could be very simple to call or check with the lawyer, my attorney, I need you to make a request to the judge. I need to go this, I need to do this. That's what the rules require. And it may not be 48 hours, it's an emergency, but contact the judge. Is it okay, to do that, rather than to go? As indicated by Mr. Moran, apparently it was done, and not anything was said when they came to court on the other matter within a day's time of the events, that were there for the other time when the judge changed the bond then. It's conceivable, obviously,